Right, okay, we are a minute or so past 10, so I'll start with the admin before we get to the Q&A. So thanks for everybody for joining us. It's nice to have some very familiar names on the list of attendees. So welcome back to those people, and good to have you with us if you haven't joined us before. This session is being recorded and it will be posted on the firm's social media sites, including YouTube and the website and various other things. So that's just to make you aware of that. This is one of a few live Q&A sessions that Forbes has been running recently, and they've been really well received, to be honest. It's been a really good discussion forum for getting all those niggling questions answered. If you couldn't attend the previous ones, then it's worth checking out our YouTube feed or going to our website, and you can see them listed there for you to play back at your leisure. This one specifically relates to health and safety generally. Obviously, a lot of what we've been discussing at the moment has centered around COVID-19 and those kind of matters. That's obviously first and foremost on people's minds at the moment. In some cases, the only thing on people's minds. But you can ask anything you want about health and safety generally, and we'll try and answer them as best as we can. If there's some questions that need a bit more of a detailed answer, or perhaps we need to get some more information from you, then it may be that we ask you to call in or email afterwards. It might be worth you doing that if you've got something that needs discussing, or if there's confidential issues that need to be discussed. This is an interactive discussion forum. I really want to encourage you to get involved. If you've got questions that bounce off the back of others that have been asked, then just feel free to chip in whenever you can. I'm sure you're all pretty used to Zoom by now in this modern age, but I think the chat function has been disabled in preference for the Q&A function. So if you look to the bottom of your Zoom window, there should be an option labeled Q&A. If you click on that, it'll open up a forum of questions that have been asked so far, including some that have been answered. And when you click to add your question, I think it gives you the option, or it should give you the option to anonymize yourself, so that people don't know your name. But we're all friends here. It's a safe space. You can feel free to ask as many questions, or even if you think they're obvious or silly, as you want, and we'll do our best to answer them. And we're booked in here, I think, for a maximum of an hour, but it just depends how many questions we've got. And we certainly won't go over that, but we'll get through as many as we can in the time that we've got. So with that in mind, I think I just need to introduce the panel that we've got with us here today. I'll start with myself just because I've already got the microphone unmuted. My name's David Mayer. I'm a partner in the large loss and complex claims insurance department. So I deal with defending higher value and complex civil disputes, mainly personal injury. I'm going to be chairing this, fielding all your questions and making sure they go to the right people. So with that in mind, first of all, let me introduce Ridwaan Omar. He's another partner in the same team as me, who again deals with defending higher value and complex personal injury actions. Ridwaan's also a higher court advocate and part of our regulatory team. So he deals with inquests and other kind of similar matters that bridge the gap between civil and criminal law. The other side of that gap is happily filled by Gareth, a partner in our crime department, also head of the magistrates and police station departments. Gareth specialised in regulatory crime for well over 10 years, I think now. So he's here to answer any of your questions about prosecutions, enforcements, HSE involvement, and that kind of thing. And last but certainly no means least is Emma Swan, partner in our employment department and head of our commercial employment section. By the very nature of her position, she works very closely with businesses in relation to all HR and employment aspects. So she has a very strong business advisory practice, which makes her a welcome asset to this discussion. So she's going to deal with all of your business and employment inquiries. She's certainly been very busy over the last few months, as you can imagine, with with all the COVID related inquiries. And if I remember rightly, I think department is doing separate Q&A sessions, maybe even today. So as have a number of other departments. So if you're interested and you're not booked onto those yet, then it's worth checking those out. So let's get the Q&A started. I hope you can all hear me properly. If you can't, like I say, the chat function is disabled. Just put a question in the Q&A, like, why can't we hear you? So we've had a number of questions that have been sent in advance of the session, which we're going to go through in turn. But obviously this is a live session, so we'll deal with any questions that are posted as they come in. During the session, you'll see me clicking and typing away and clicking and etc. as I redirect questions and field them to the right people. So if you see the side of my face at the top of my head from time to time, that's what I'm doing. Apologies in advance for that. So I think we'll start. One question that we had sent in advance, I think, is probably best answered by Ridwaan, if that's all right. So the first question for you, Ridwaan, is, do you think that councils will get many COVID-19 related claims? I've heard it mentioned that it'll be the next big money maker for claimant solicitors.
Morning, everyone. Obviously, the way the question's been asked is clearly it's angled at a civil, from a civil perspective. There are three aspects to that question, actually, and three issues. I can deal with two, and I'm then going to defer to Emma in relation to the last issue. From the council's perspective, let me start. There's a health and safety aspect to that. In terms of the enforcement would be undertaken by the HSE. The HSE themselves have provided quite a lot of guidance, weekly updates, a lot of information on their website in relation to ensuring workplaces are COVID-19 compliant, businesses, organisations are ensuring that workers are adhering to social distancing guidance, as well as to ensure that there, steps such as staggering shifts, ensuring workers come in at different times, to avoid overcrowding, for example. So there's those aspects from a health and safety perspective. The question from reading it in terms of the mention of claimant solicitors and whether it's the next big thing for councils to face is more, I can see coming from a civil perspective of that question, and please feel free to correct me if I'm wrong in that, and ask the questions within the Q&A if it needs clarifying. As far as the civil claims are concerned, again, there's two aspects there. There's compliance with guidance, which is the same guidance that the HSE have provided in terms of, and the government have provided in relation to ensuring cleanliness in the workplace, social distancing, and ensuring that employers are undertaking COVID-19 risk assessments. It's really important. In terms of civil claims themselves, yes, there is a requirement to ensure that if you are a frontline worker, that you have adequate PPE, for example. Are councils really going to see claims? They may well see claims, but the biggest hurdle that certainly legal commentators have touched upon in since lockdown is really in relation to causation, which are factual causation, legal causation, as well as medical causation. Exactly how can an employee or someone making a claim against the council prove albeit on the balance of probability, that they were exposed to COVID-19 virus from the workplace. And I don't believe there is the scientific evidence available at the moment to say that someone has actually caught or contracted COVID-19 from a certain workplace or certain place. And that's going to be the biggest hurdle or the biggest battleground in relation to certainly civil claims. That's not organisations, councils alike shouldn't be complying with guidance. They certainly should be. It comes back to my first question, the first issue I touched upon in relation to the health and safety, the enforcement from the health and safety executive. There's certainly, and very recently, very compliant, ensuring and sending the message out that businesses, organisations need to ensure that they are COVID-19 compliant. The third aspect of claims potentially is employment and stress claims. And I believe, Emma, you can probably address that better than I.
Thank you, Ridwaan. Yes, just in relation to the stress at work claims that may be brought in the Employment Tribunal, the first thing to bear in mind is that you are very likely to have an indication of this coming your way before it gets anywhere near the point of someone trying to bring a claim, because it's likely to be that people who are stressed or feeling anxious or depressed about returning to the workplace, or might have been experiencing those conditions, being on furlough. I know we've got a couple of organisations here who will have used furlough, albeit the councils are unlikely to have, or people who are juggling working from home with stressful home lives. And you are likely to have employees saying something first, whether they say something informally to their line manager or raise a formal grievance. So there is going to be opportunity to head some of those claims off very early on. But the one to really be alive to is those individuals who are suffering with stress, depression, anxiety to such an extent that under the Equality Act, they are going to be considered to be a disabled person, because that gives rise to an obligation on us as employers to make reasonable adjustments for that person. So, for example, if you have somebody who doesn't want to return to the workplace because of that anxiety, that stress, that depression, then a reasonable adjustment may be to allow them to continue working from home if they work from home going forwards, if you haven't already. And there's some of the areas that we would foresee potential claims. The main concern for employers with Equality Act claims is that someone can bring those claims whilst they remain an employee. So you then have the ongoing employment relation issue to deal with as well. It's highly unlikely in my experience and my view that you will see employees resigning and trying to claim constructive unfair dismissal as a result of being unsupported with any anxiety and stress because of the uncertain job market. So that is less of a risk. But equally, in both scenarios, you want to make sure that you're addressing those concerns as soon as possible to make sure that you've not got problems down the line. Thanks a lot, Ridwaan.
Right. Okay. Thank you, both of you, for that. So I suppose the advice there is get in early when you've got a notice, when you're on notice about potential claims, and deal with them before they get too far. And then if they do start coming out of work, then it's dealing with the causation issues, as Ridwaan's mentioned. Right. That's useful. Thank you for that. Okay. The next question that we had is going to be for Ridwaan as well, actually, whilst I've got you there. Somebody's asked, how have the Ministry of Justice reforms affected the level of claims? Since the reforms are the courts processing cases quicker, have the percentage levels of compensation paid to injured parties increased? So general queries, I think, about the Ministry of Justice changes, not specific ones, no specific ones mentioned, just the Ministry of Justice reforms generally.
I can certainly answer that from a civil perspective. I'd probably defer to Gareth as far as his experience is concerned in both magistrates and the Crown Court are concerned, but certainly we are helped by publication of the MOJ civil statistics very recently, as recent as the 4th of June of this year, showing the trend between January and March. So it's just pre-lockdown phase, so this will probably not be representative of the post-COVID-19 lockdown situation, but from personal experience, I can give you my perspective on that. Just looking at some of the stats from the MOJ statistics, between January and March of this year, they received 489,000 claims, actual decrease by 9% on the previous year. In relation to unspecified money claims, and those would include the types of claims, including personal injury, for example, those are down by 8% to 30,000. PI claim, personal injury claims themselves are down by 11% from the previous year to 27,000 claims. In terms of are the reforms of the courts processing cases quicker? Well, again, quite helpfully, the statistics provided show there's actually been an increase in the time spent in processing claims. So small claims cases are taking approximately 40 weeks to resolve from issue to final resolution, and fast track and multi-track cases are taking longer as well, up to 60 weeks in relation to that. So all those figures are certainly up from the 2019 figures. The third aspect is in relation to the level of compensation paid. Actually, the current situation, current reforms makes no difference in relation to that. There had been previous reforms where compensation was increased generally by 10%, and the Judicial College guidelines provided for that increase. Those have been in operation for a number of years now. Certainly the current situation with people, employees, if you have an EL claim, you probably will find that you can probably, if a claim needs settling, you can probably get a good settlement, because employees will probably want to settle claims at this stage. And so certainly for insurers, for councils who are self-funding, this is an opportune moment to really narrow the issues and try to settle as many claims that need settling, in truth. I'll pass you to Gareth. He'll probably be able to update regarding the impact on the criminal side of things. But just the final point I make in relation to civil claims is there is a considerable backlog of cases. We're seeing that certainly courts are much slower in processing claims. They're much slower in getting formal directions out to parties. They are just dealing with essential work at the moment. And certainly some trials are going ahead in terms of multi-track cases, but certainly I've seen a lot of fast-track cases actually being vacated and put off for a later date to be relisted. So surely, slowly but surely, the courts are coming to the realisation they can't just kick cases into the long grass. They are having to deal with them. So there is a systematic way of trying to deal with them as we go forward. Gareth, if you can give an update from a criminal perspective.
Thank you, Ridwaan. Good morning, everyone. The COVID impact on the criminal justice system has been significant. Every case, every enforcement case starts in the magistrates' court. Some end up at the Crown Court, but every case begins in the magistrates. And nationally, there is a backlog of fast approaching 500,000 cases that need to be heard through the magistrates. The method to try and deal with that backlog is to identify 3 levels of priority, and usually matters that involve prosecutions by the Health and Safety Executive or other enforcement bodies are considered priority 3 cases, which is the lowest level of priority for the magistrates listing offices. That means, unfortunately, that cases are just being pushed back further and further and further, with a realistic expectation that any contested matters, so trials, will probably not be heard at all during the rest of 2020 and probably spring of 2021 in reality. And as Ridwaan said, the consequence of that delay is that there is an opportunity now to try and resolve cases. Significant pressure is being put on defendants and indeed on prosecuting authorities to look to do plea deals, to look to reduce allegations to less serious charges, or to take cases out of the criminal justice system entirely. And certainly we've seen a recent example of a fairly serious enforcement action that was ultimately compromised by a caution using COVID as a decision, a factor in the decision to remove the case from court and deal with it in that very favourable way to the defendant. So lots of pressure on the criminal justice system, but I think lots of opportunity in the right sorts of cases for those who are being investigated. Thank you, Ridwaan. Thank you, David.
Thanks both of you for that. Yeah, very interesting actually. I've noticed myself in my cases the number that are either being compromised or pushed through or perhaps dealt with in a slightly different way because of a change in circumstances. I suppose probably any kind of litigation type area is probably facing different pressures than they were beforehand, but it's not from the criminal justice system side of things, not something I'd thought of before actually, so that's interesting to know. I suppose probably Emma's probably experienced a similar thing as well with her cases. Okay, so well, staying with you whilst you're here and on my screen, Gareth, as far as your caseload of things go, we've had a question sent in that says, what is the HSE's approach to COVID-19 compliance, including their enforcement strategy? What are they? I've had quite a few emails and things recently from the HSE, but what are they? How are they actually approaching things during this difficult time?
I think the HSE are very aware of the backlog with the cases, and that is impacting the way in which that they are enforcing COVID compliance. I think what we'll see is a range of enforcement strategies depending upon the organisation that they're dealing with and the impact and the risk perhaps that's created to employees. Initially, I think the view adopted by the HSE will be one of encouragement and advice to try and assist employers getting into place their COVID compliance and to assist wherever possible, rather than taking enforcement action unless absolutely necessary. I think we've seen some examples of perhaps where there are real concerns, particularly arising out of the situation in Leicester with some of the manufacturing operations that have been going on there, and suggestions that because of the continued operations in situations that were perhaps not COVID compliant, that there may be more significant enforcement action. But I think with most organisations, we can expect to see encouragement and advice at the early stage, followed, if need be, by some of the less formal methods of enforcement, so improvement notices, prohibition notices where required. And only then, I think, will we look to see the HSE start to take action through the courts, because, of course, they're going to appreciate that any action that they start now may not be heard before the court for many months, and perhaps for those reasons, where they can, they will take a more gentle approach, I think, certainly at this early-ish stage.
Okay, so interesting. So again, another effect from a kind of pressure from the pandemic on dealing with cases kind of expeditiously and cost effectively from the agency's perspective as well. Have you got any kind of complying with the law, I suppose, is the best way to prevent prosecution, but I mean, is there any way that anybody, any methods or anything that people should be using to kind of prevent involvement from the HSE, or kind of any way they can protect themselves that they might find useful?
Certainly, I think there's a couple of relatively easy things that people can do. The first, of course, is to make sure that they've got their COVID-19 risk assessment in place. And I think it's very easy to assume that we've made that risk assessment, particularly back in February, March, when the situation was building, and then we think that's a finished document. But of course, it's not. It's a live and evolving document, or it certainly should be. And as government guidance changes, and there's talk about perhaps the slight shift in government stance from the encouragement to work from home, perhaps towards moving towards encouraging people back to working in their more normal workplace, the document should evolve as well. And so I think that's the most important thing, is to document the changes, the reviews of the risk assessments as they happen, so that if you were visited by a health and safety inspector, you can produce the series of documents and show the transition of that document over the months. And I think the second, perhaps may sound blindingly obvious, but I think the second thing that you can do is talk to your employees. They are the people that will know the real risks that they might face in day-to-day operation. The more you talk to them, the more information you can get from them, the more knowledgeable you are, and of course then the better you're in a position to take steps and minimise the risk. Because of course there's an obligation upon all employers to try and reduce the exposure to risk for all of their employees. And health and safety enforcement is not about injury, not about actual harm necessarily. It's about that risk of harm and preventing it from happening. So employers, by talking to their employees, will be able to identify perhaps areas of risk that they hadn't in themselves picked up, and they can factor those into the risk assessment documentation. Ultimately, I think with the health and safety executive, it comes down to be able to produce pieces of paper. They like to see that a thought process has gone on, and that they can produce a written document that can be handed over as evidence of that thought process. So I think those are the two key things that I would suggest that anybody does. Thank you.
Thanks, Gareth. Yeah, that involvement of employees is a kind of key theme, I think, throughout a lot of these Q&As that we've been doing. It's I think that probably is quite key to a lot of queries that people have posted. We're going to stick with the HSE theme for the moment, because one of the other questions that we got through, I think, it's probably best answered by Ridwaan again. We'll come to Emma next, because we've got some employment-related ones as well. But just to deal with this section, Ridwaan took us through some statistics before, but the annual HSE fatality statistics have now been released. So the question we had was, what does that tell us for those working in the health and safety sector?
Yeah, very right off the hot press, to be honest. The HSE published their annual figures on the 1st of July. This covers the 2019-20 the year. It's pre-COVID, so these figures will not include any COVID-19 related deaths. What do they show us in a nutshell? Well, certainly construction claims or fatalities arising from certain industries, including construction, are really high risk. 40 deaths over the last year. Manufacturing, certainly for those local authorities here, waste is still there. It's not, there's been many improvements made within the waste industry, but the figure in relation to waste is still 5 fatalities relating to waste and recycling. So I know local authorities, I've personally been involved in, and Gareth as well, in a fatality involving a bin wagon, for example, with a member of the public. So these are types of risks, certainly for local authorities to be aware of. They are still featuring in quite high numbers. Overall, the figures for 2019-2020, the April to April stats show 111 workers were killed. So that is a decrease from previous years. In terms of the causes, it's falls from height, being struck by a moving vehicle, and being struck by moving objects are the 3 main causes for fatalities. But it's not just workers that are actually affected or killed in the workplace or killed by work-related activities. The stats also show us that there's been 92 members of the public actually killed due to work-related activities as well, which is, in the context, is quite a high number in truth. So these are probably preventable incidents where certainly enforcement authorities such as the HSE will be looking at risk assessments, ensuring that you have safe working procedures in place. In terms of the impact of COVID-19 on the statistics, we're going to have to wait till July next year before those numbers or those statistics are released. Hope I address that.
That covers that. Thanks, Ridwaan. That is a really surprising statistic, the number of members of the public who've been killed from those kind of, because if construction and waste and those kind of things are the biggest sectors, and that suggests that members of the public are being fatally wounded by those activities. So that must be things falling off construction sites or trucks being kind of hitting people or whatever else it may be, which kind of seems to be eminently preventable, doesn't it? But yeah, that's really surprised me, actually, to be honest. I haven't seen those, I haven't read those statistics yet, so it's good to know.
Just clarification of the 92 members of the public, 51 relate to work-related accidents, 41 deaths actually relate to, or deaths that occurred on railways. So that's how the breakdown of 92 arises.
Right. So yeah. So those are included in those statistics. Yeah. Still high, isn't it? Actually, though, for that, you'd think you can understand on-site accidents, but affecting members of the public, you'd think would be quite unusual. So, okay, brilliant. Thanks, Ridwaan. Right. So just turning now to the employment-related questions that we've had sent in. So these are for you, Emma. We had quite a few of these because they're obviously quite high on people's agendas at the moment. But and there's quite a common theme of home working. So the first one we had is, when an employee returns to work in the office from home working through the COVID-19 pandemic, can they justify becoming a regular home worker and consequently refusing to spend full-time hours in the office? In other words, what can be done to prevent the employee refusing to return to full-time work in the office? It's quite a few aspects to that, but you can address that, Emma.
Thank you, David. Yeah, the starting point really is, what does it say in someone's individual contract of employment? And if their place of work is in the office, the workplace, the site, etc., then even though they've been working from home over the last few months as a result of government guidance and the pandemic, that hasn't changed their contract of employment. Now, some employees might try and argue that it's become custom and practice that they have been working from home. But in my view, the tribunals will not see this as a long-term custom and practice that will enable an employee to insist that their contract has changed to home being their place of work. work. So that's the starting point to ensure that employees understand clearly that whilst this is a temporary measure, it is not a change to their contracts of employment. The second thing to bear in mind is that employees do have the right to make flexible working requests in a wide number of circumstances. So for those people who have possibly got long-term concerns about their health and their anxiety, etc., you may see that some people are making requests to work from home as part of a flexible working request. And what you will have to think about carefully as an organisation is whether for business reasons you have a reasonable explanation for saying no. So it may be that parts of their job they have been able to do from home, however some parts they've not been able to do at all and they need to be in the office to do those things, or it may be that their productivity has dropped significantly working from home, and that is because they work much more productively in the office. So for those reasons you may be able to turn around and say no to somebody to a request to change their contract of employment to being home working. Now, there has been a little bit of speculation as to whether Matt Hancock and the government are going to announce a new law to say that people have the right to work from home. We've not really had much substance from the government on that, and certainly given the message that we've had over the weekend from Boris encouraging people to go back to the workplace, personally, I don't think that we will see anything giving employees an ultimate right to work from home if that's what they want to do, as opposed to what the employer wants them to do. But the key message really to try and avoid problems with employees is communication. I suppose it mirrors a little bit what Gareth said about one of his tips from the risk assessment angle, is talking to your employees and making sure line managers understand why people might be reluctant to come back into work. Is it because they are anxious about it? Or is it that they now see working from home as a bit of a perk, it's given them a better work-life balance and they want to continue? Or it may be that some people actually find that they work a lot better, they're a lot more productive at home. So it will very much be a case-by-case basis that you might want to tackle this initially before deciding whether you have a blanket ban on home working going forwards, or whether ultimately you do want to see people being encouraged. At the outset of the lockdown, there was an awful lot of commentary about this is going to change the way that businesses operate, that everyone's going to want to work from home going forwards. But what we're actually seeing through a number of employee engagement surveys that have been conducted during lockdown is that it's actually a really mixed bag, because there are some people who are working from home that simply are not enjoying it, whether it's because they've been trying to homeschool children at the same time, whether they're sharing workspace with other individuals and that's made it difficult. They might be missing the social aspects of work, or it may come down to that health and safety aspect, that they are not set up to work from home properly and they are struggling with backache because they're sat on the couch with a laptop. They're struggling with their eyesight because they've only got a very small screen as opposed to 2 screens that they might have at work. So there are a lot of reasons why people will want to come back to work, and also that employers will want to ultimately use as business reasons to encourage people to come back to work as well.
Okay, thanks, Emma. I mean, you've covered a lot about home working there, and a couple of the other questions we had were related to that same topic, some of which I think probably overlaps with some of that, and I just want to make sure nothing's missed. So somebody had asked what you do from a HR perspective if employees are concerned about potentially refusing to the workplace because of risks to health, presumably to their own or to other people's health, other people in their family, or if employees have been working from home and want to change to permanently working from home. Is there anything extra to add about those particular questions? Or?
Yeah, I think picking up slightly on what I said earlier on the stress-related question that Ridwaan had asked me as well, is one of the things that we've got to be mindful of is the reasons why people want to work from home. Because if it does come back to a protected characteristic such as being disabled and wanting to work from home because it's going to serve them better to work from home, then there is going to be an obligation to look at that. there's also the right to make a request for flexible working, which includes working from home. But ultimately, if an organisation for business reasons needs people to return to the workplace, they have carried out those thorough risk assessments, they've spoken to their employees, and they're trying to address as many of those concerns and potential risks as possible to enable people to come back to work. If individuals then unreasonably refuse to come back to work, they don't have genuine health concerns, they don't have genuine health and safety concerns, then disciplinary action can be taken against them, because their contract is that they are to work in the workplace. I anticipate that the guidance is going to be more formally changed to encourage people to return to work, rather than at the moment it's stating you should work from home where you can. I suspect that's going to be tied in with schools going back in September, because of course at the moment over school holidays a lot of summer clubs aren't going to be operated by schools or other providers, so childcare is going to be a big issue for a lot of working parents. But I think from September, guidance from the government will shift. Contracts won't have changed, because this is the temporary measure only, so there's no long-term changes there. So if people are objecting, refusing, then ultimately they're breaching their contract, and it could be an unreasonable refusal of a management request for them to return to the office. So people do have to be very careful in saying no to their employer, but also just a word of warning to employers who may want to insist, who haven't taken all the steps that they should have done. If you do discipline or you do dismiss someone who has raised genuine concerns for health and safety, either of themselves or their colleagues, then you could then be facing a claim from someone. Particularly if you dismiss someone, it would be automatically unfair to dismiss someone who has got genuine concerns. So it's really important to communicate properly with your employees to understand what the issues are. Make sure you have got all that paperwork in place to show that you have gone through proper risk assessments, you have taken the necessary steps, and also you've got a series of records of having had discussions with employees and try to allay those fears before you take any formal action against them. I think that answers all of those last bits for you, David.
Yeah, it does. Yeah, thanks, Emma. Yeah, very comprehensively. Thanks for that. Okay, right. Slight change in direction, I think, on these next few questions we've got here. So this one is going to be, I think, best answered by Gareth. Had somebody who sounds a little bit nervous about the situation. Anonymously says we've heard we've heard from Ridwaan so far, haven't we, about the potential for civil claims, but we're starting to hear about furlough fraud investigations in the press. So the question that has been sent in is that something that we think we're going to see more of in the future, and what are the consequences for a business of those investigations and prosecution?
Thank you, David. I think we definitely will see more. You've just got to look at the cost to the government of the furlough scheme to see that there's a real incentive for the enforcement agencies to seek to recover any furlough monies that have been paid out fraudulently. We've had the first arrest over the course of the last couple of weeks. There were 8 individuals arrested following an operation in the West Midlands, a fraud there valued at the best part of £500,000. And it's very clear that when you've got a scheme in place that's supporting nearly 10 million jobs across over 1 million employers and costing the government a significant sum of money, that there's going to be a real appetite to investigate. There are a number of surveys that have been conducted recently where employees have been asked to report incidents of furlough fraud, where they've been asked, for example, to work by their employers when they shouldn't have been working. And almost a third of employees report some form of request to work during the course of furlough. And the number of reports is increasing exponentially. There were about 800 reports of fraud by the 12th of May. By the 29th of May, that had gone up to almost 1,900 reports. So with employees reporting these instances, I think organisations like the HMRC and the police will be very interested in taking action. The downside, I suppose, for those investigators and the upside for those who might be investigated is that the size and the scope of the investigations is going to be vast. It's going to take a lot of time, it's going to cost a lot of money, and so of course there's that balance to feature. In terms of the consequences to any organisation who's investigated, I think the most significant one is just the reputational damage. We saw a lot at the start of furlough, a number of companies who were criticised for taking advantage of the furlough scheme in situations perhaps where members of the public felt that wasn't an appropriate use of the government's support. And of course, what might follow on from that is where those organisations are outed as using furlough fraudulently. The reputational damage will be significant. The cost, of course, will be significant if you are successfully prosecuted, because I suspect that the investigative costs that will be pursued will be into the six-figure sums without any difficulty at all. So yes, it's definitely something to be alert to.
Thanks, Gareth. Yeah, I suppose, as you say, in any high-value scheme involving the government, then there's a real incentive there, isn't there, to protect that with protect its own resources. So that makes sense. Okay. I mean, whilst we're on those kind of issues, somebody had asked a question about other things that have been in the news at the moment, like the Boohoo scandal and modern slavery implications. Is that something that you've seen? Is that something that's prosecuted a lot? And what the question that they asked was what lessons can we learn about what we know about it? I'm not sure whether that's in relation to COVID itself or the modern slavery aspect of it or what, but you can answer that as best as you can.
It's not something that's widely before the courts at the moment. Obviously, it's certainly high profile, linked to the Boohoo situation. It's probably not helped by the definition of modern slavery under the Act, which is a fairly convoluted way of describing when somebody may or may not be in a slavery situation. But I think there's an increasing appetite amongst those enforcement bodies to look into what was perhaps perceived to be not a particularly British situation. You perhaps think of modern slavery in terms of the workplace, and you think of perhaps other countries, but the situation in Leicester, which was precipitated on the COVID investigations, I think is going to encourage a lot of interest, because remember, going back to when the corporate manslaughter legislation came in, there was a real push by police forces to be seen to be the first area, the first force in the country to successfully prosecute for corporate manslaughter. And I think we might see something similar here because of the press coverage that goes with it, because of the significance of some of the targets of these investigations. I think there will be a real appetite and perhaps a race at some stage to try and secure a conviction. In terms of what you can do, well, obviously review your workplace operations, obviously make sure you're compliant with things such as national minimum wage payments where necessary, look at working hours, look at the conditions in the workforce. All of those things are matters that will be taken into account when you assess whether somebody is or is not in slavery. And of course, the fact that the, in inverted commas, slave consents to be in that situation is completely irrelevant, because of course that consent is perhaps not properly given if they are in a slavery situation. So yeah, another area I think that we'll see some interesting growth over the course of the next maybe 6 or 12 months time. Hope that answers the question.
Yeah, it did, thank you. Yeah, growing area again, right? Okay, useful to know. We've probably only got 5 minutes or so left of questions. So if anybody does have any other live questions that they want to send in, now is the time to do them. Otherwise, we will run out of time. We have got a few extra questions. We're probably not going to go through all of them. The ones that came in advance. I did see one which I thought might originally be for Ridwaan, but you've all mentioned a couple of different things whilst we've been answering other questions. So probably, I think, just to open up generally to the panel, if anybody's got any ideas. But there's 2 questions, I suppose. If we deal with the first one, someone said, what if our work premises or work type do not lend themselves to effective social distancing? So I suppose if they're doing a particular type of work, maybe, I don't know, construction or something, working in confined spaces that make social distancing difficult. What do they do about that? I mean, from my own perspective, social distancing isn't a mandatory requirement as such. It's an advisory in terms of assessing risk. So I don't know if anyone's got. What if people are going to work and finding they just can't stay away from other people? Is there a way to minimise that, or a way for employers to protect themselves with that?
I mean, taking apart from the health and safety risk aspect of it, one of the things that we're working with a lot of employers to do is looking at operating varying shifts, rotas, so that people are actually limiting when they are in the office to set days, so that not all the staff are in at the same time, they're not arriving at the same time. To try and limit that risk of people being in close proximity. I don't know if Ridwaan or Gareth have anything to say more from the mitigation risk in terms of PPE or what have you.
Yes, certainly in terms of that type of question, the key to it is going to be the COVID-19 risk assessment. That's going to be, if there was going to be any health and safety investigation in relation to the workplace itself, the first port of call will be that COVID-19 risk assessment. What steps did you take? What assessments were made? And it then leads on to the questions that Emma has raised in relation to, and Gareth, I think, has mentioned previously, in relation to staggering work times, being flexible in relation to that. Certainly, we talk about one-way systems. I've seen it in a education type setting where they do have entry and exit points on a one-way system. Actually ensuring that people are trying to social distance, and they've been educated and instructed and informed in relation to those aspects. But all those different factors I anticipate will be brought out during the course of the COVID-19 risk assessment that's undertaken, including hand washing facilities as well, which is obviously one of the key issues that the government had really emphasised on in relation to ensuring that the transmission of the disease, of the virus, is actually restricted.
That's great, thank you, both of you. We've had a question that's come in on the Q&A, which says, should a company have a modern slavery policy statement which states they implement training for their employees on the matter, yet they do not undertake this in practice? What are the risks of that? So should a company have a modern slavery policy statement which states they implement training for their employees on the matter, yet they do not undertake this in practice? What are the risks of that? So I suppose if you have to so it's a question about having the theory behind it, but not executing on that. But if anybody has anything they want to contribute to that, or they can say about
that. I suppose it raises the interesting question as to where there is greater risk. Is there greater risk in having a policy and then not adhering to it, or not having a policy or mission statement in place at all? The difficulty, of course, if you have the statement, is that you demonstrate to any enforcement agency that you've thought about that area, identified it as being a potential area of risk, and then not gone on to manage it by not putting in place your own published policies and procedures. So I think there are risks. I think if you're going to publish a document that sets out a particular mission statement on any topic, whether it's modern slavery or any other risk area, you do increase the risk if you then don't follow your own published procedures. And when you look at the sentencing guidelines that exist for general health and safety offences, one of the aggravating features identified is a failure to follow your own policies. So it's a good step to have the statement. It's an even better step to follow it and to review it and to update it when you need to. I hope that answers the question it was asked.
And there is actually a requirement for those businesses that supply goods or services and have a consolidated global turnover of 36 million per annum or more, that they have to prepare a slavery and human trafficking statement for each financial year. So I know that we don't have many organisations on the group today, but there will be a lot of our clients out there who do have that kind of size turnover. And will be obliged to produce the statement as well and publish it.
Okay, that's great, thanks. Both of you. I suppose this is something that we probably all see. I certainly see in my practice that where people have documentation in place that they've done as a kind of tick box exercise to cover themselves with the legislation, but have no real kind of desire to follow through on it and to enforce it, then it can get us to real difficulties there. I see people a lot who have risk assessments of various different things and method statements or work instructions, but then don't actually make sure that they're followed. And then, as Gareth said, the difficulty you've got there is you've got it written down in black and white, and then it's not actually being followed. Then that's they're going to start, questioning why you've got that in the first place. That's going to cause some real difficulty.
I think as well, David, that one of the big issues that the boohoo scenario creates for a lot of organisations is that within your own business, you might be satisfied that everything is okay and above board, but you need to look at your supply chains and you need to make sure that you've got really rigorous auditing processes there. And also that from a commercial perspective, that if you've got terms and conditions in place with supply chains, that you make sure that you put a very strong contractual obligation on them to make sure that they're doing things as well. Because the impact on boohoo, who haven't themselves been operating, as far as we can see, in an illegal way, the impact on them and their share value has simply been because of their supply chain and them not necessarily ensuring that their supply chain has done what it should have done. And that is a huge risk for organisations, whether the public sector or private sector. I think it's that damage to reputation.
That's great. Yeah, thanks for that, Emma. Okay, well, we've come to the end now. We've had our hour. We've done quite a lot of questions there, so I don't think we've had any last minute questions in to deal with before we go. So I think we'll kind of draw things to a close there. First, I'd just like to take the opportunity to thank you all for your attendance and had some really good questions. Hope the answers have been useful to you all, and also thank you to the panelists for all their help and guidance during this. If you do have any other queries for any of us specifically, or anything that you want to raise, then after the session, then if you go onto our website, you can find us all on there with all our contact details. Our email addresses are just our name with a full stop between the first and surname, and then @forbessolicitors.co.uk at the end. We're on LinkedIn and Twitter and all those different things. It's impossible not to find us if you want to track us down. If you are interested, we do various employment. I've got quite a few packages to help you through these kind of difficult times, furlough packages and audit assessments and that kind of thing. And our other departments have various other packages to help businesses as well at the moment. So if you do want to find out anything more about anything that's been said today or anything else, any other services we can offer you, then please do get in touch. We're always happy to speak to you and to help. So I think all that remains is for me to thank you for your time. Thank you for joining us, and hopefully we'll see you at one of our other sessions, and maybe even in person at some stage soon. Who knows? May not be in the too distant future. We'll see. Thank you, everybody, and I hope you enjoy the rest of your day.